Yes. So, good evening, student friends. You are all aware that you see from 1st of July we have started off the virtual classes for foundation, for intermediate, and for the final course relating to November 2020 exam. I hope you are enjoying the classes. I think you see, I have spoken to you for so many times, but those of us who are successful member, and we have with us Mr. Sanjeev Kumar, who is the ED of Insolvency and Bankruptcy Board of India. About I will later. You see enjoying the classes that we have been having, the virtual classes. We have been trying to get the best of faculties to come and share. So, see, those of us who have not given their feedback, please see, I should request all of you again. Executive Director of Bankruptcy and Bankruptcy Board of India, A.R. Sanjeev Kumar with us. And Bankruptcy Code. Now, please note, those of us who are especially the final students, you are aware that the Insolvency and Bankruptcy Code, you see, was there. It has come into being from 2016, and it is one of the most significant piece of legislation in recent times. One of the most significant piece of legislation. The Institute of Chartered Accountants of India, we have formed our own insolvency professional agency, and we are also, playing a very important role. Is a hand in hand with the Insolvency Board of India. So is the Insolvency and Bankruptcy Board of India. Now let me speak a few words about Mr. Kumar. He is, as I said, he is the Executive Director, and then he handles the legal affairs, the professional education part of things, and of course the knowledge management. Very, very important from our point of view, what he does. He was with the Ministry of Law and Justice, and he was elevated as a Joint Secretary of Ministry of Law and Justice in April 2015. Holds a degree in Science and Law. Please note the combination. He holds a degree in Science and Law. Mr. Kumar, at some point of time, was also a practicing lawyer. So he has a legal bent of mind, which is very important for a new legislation like this. And those of us, who are, of course, have some kind of a inclination towards income tax. During his 10 years, he has also handled finance bills. So, Mr. Kumar, a very, very hearty welcome to you on behalf of the Board of Studies of the Institute of Chartered Accountants of India. It is our great pleasure to have you with us, and I'm sure the students would feel extremely benefited and enriched by the insights that you are going to provide to them. So with these words, may I request you to kindly address the students. Then after you, Past President Subodh Agarwal will speak. So Mr. Kumar, please, the stage is yours.
Thank you. A very good evening to all of you, Mr. Debashish Mitra, Mr. Subodh Kumar Agarwal, Mr. Sushil Goel, and Ms. Vandana, and all the students who have gathered to listen to us this evening. You must be enjoying your time because your exams have been postponed, and I'm sure that as chartered accountants or budding chartered accountants, you must have had a bird's eye view of the Insolvency Bankruptcy Code, as rightly by Mr. Mitra. I think one of the most innovative economic legislation that our country has ever had. And it has just been passed a couple of days before. profession, you must have noticed that there has been sea change in the business culture in our country. The business, both credit and debt culture, has changed. There is a great awareness among the stakeholders to abide by the law, to do business and to do business legally, and after servicing your debt. That is a big thing that has happened. And there has been a big boom to the professions, especially chartered accountants. Why I am saying chartered accountants, it's because most of the insolvency professionals, like Mr. Subodh Kumar Agarwal, he'll be able to tell you the advantages of the profession. Most of the IPs are chartered accountants, and then company secretaries and cost accountants. My fraternity, lawyers are very few and far between in this profession. Because chartered accountants know business, chartered accountants support business, chartered accountants know how to conduct business and how business is being conducted. So they are the best suited persons for insolvency profession. So you become a chartered accountant, there is big opportunity as insolvency professionals for you. And there are other opportunities, supporting opportunities for you in the insolvency profession. Now, in fact, as the matters stand today, the qualifications for insolvency professional is minimum 10 years of experience as a chartered accountant or company secretary or a cost accountant or a lawyer, and 15 years experience as a manager. But now we have introduced a new course, program, which is called the Graduate Insolvency Program. This is a 2-year program. 1 year comprising of classroom studies and the other, comprising of practical experiences, and also attachment with senior IPs, experienced IPs, IP firms and other institutions. And this will shape you to be an insolvency professional without having this 10 years of experience. So those who are going to graduate and get their CA degree, they will be directly in a position to join this course, this graduate insolvency program, which would enable you to directly, practice after taking the limited insolvency examination conducted by the yourself with one of the IPAs. As Mr. Mitra said, Chartered Accountants Institute has set up an IPA, and then you can take the pre-registration course. It's a 50-hour course, and then you can register yourself as an insolvency professional. This is one of the most important professions that has emerged in the last 3-4 years in this country, and it's a very rewarding profession. You as insolvency professionals, you will be conducting the business of the corporate debtor. You will be chairing the chief executive officer's chair. When you take over, the board of directors of the company will be suspended. So practically you will be in charge of the business, and you have to find insolvency resolution of the corporate debtor, and you will be handing over the business of the corporate debtor to a new resolution applicant, new business entity, new business person, and then successfully you will be able to complete the processes. So the law is very simple. The processes are very simple. It's a time-bound process. It is not like the other regimes we had in the past for insolvency, resolution, restructuring, and recovery. So IBC is not a recovery mechanism. It's a resolution mechanism whereby the debt-ridden corporate debtor will be freed of the debt. Right, you are finding a resolution for the insolvency, and this is a very good cause for professionals to get in, newcomers, youngsters to step in, because you have a lot of energy, enthusiasm, and you have fresh knowledge. So I urge all my chartered accountant friends, prospective chartered accountant friends to come to this profession. Your services are required for this, because now that as on today we have only 3,000 odd insolvency professionals. Some of the provisions of insolvency and bankruptcy code are yet to be brought into force. For example, we have two phases of individual insolvency provisions which are yet to be brought into force. The insolvency and bankruptcy relating to partnerships, firms and other firms, and other individuals who do not have any business. Now that we have corporate insolvency resolution process which is running, and also the insolvency and bankruptcy relating to personal guarantors to corporate debtors. So as we expand, we require more number of insolvency professionals in many capacities, like insolvency advisors and debt recovery officers and many other areas. So this will help the young professionals to get into a new and innovative field and to expand your career prospects. Now, I would like to call upon my young friends to come in large numbers and take part in a quiz program we are organizing. We have already launched the program. It's an national online quiz which is up and running, which has started from the 1st of July 2020, and this is available online till 31st of July 2020. The details are available on our website. Insolvency and Bankruptcy Board of India is organizing this with the help of and in collaboration with the MyGov portal, mygov.in, which is a citizen-centric portal of the Government of India. And they are hosting many quiz programs, and ours is one of the programs that is running right now. So please take part in this quiz program. The first prize is 100,000 rupees, 1 lakh rupees, and the performer will get 50,000 rupees and a silver medal. The third will get 25,000 rupees and a bronze medal. Besides this, we are planning to give special, awards, certificate of merits to all the 10%, people who are the top, in the quiz program. So all top 10% people will be getting a certificate of merit from MyGov and Insolvency and Bankruptcy Board of India. And we are also giving participation certificate from the MyGov and IBBI side to every person who participates. Immediately after you participate and you logged down, you will get a participation certificate. So this is an opportunity to refresh your memory. You must have prepared for your chartered accountant examination some part of the insolvency and bankruptcy code and the processes and the regulations. So many things may be live in your memory. So please attempt this. This is an opportunity to test your own knowledge, and this will equip you to take your examination in a better way November. So this is what I just want to tell you about the profession and the processes. You must have seen the processes under the code are very, very, very simple. It's not like the other processes, other recovery or restructuring processes which was there already in other forum. Now there is a simple form of application. With that application, you can trigger insolvency before the adjudicating authority, which is the National Company Law Tribunal. It's the tribunal which is created under the Companies Act, but this tribunal is the adjudicating authority for the purposes of corporate and other insolvency resolution process for the time being under the code. So we have not created any new tribunal for this. Of course, some part of the process is dealt with under DRT as well. So those things you will study when you will be able to learn when we introduce the other part of the individual insolvency. So I don't want to take much of your time because you have Mr. Subodh Agarwal, who is a very experienced professional. I had the fortune to share the dais with him some time before, and other professionals, Mr. Goyal and others. So you will be able to listen to them. So let me once again call upon you to take the quiz and also familiarize with the law, because this is an opportunity that is, low hanging for a chartered accountant and a prospective chartered accountant. You don't need to work too hard, because this is already part of your curriculum, your syllabus, and it is very easy and simple for you to understand. For a lawyer, for a manager, it may be a little difficult, but for accountants and auditors, it will be very easy. For company secretaries too, it will be very easy to understand, because this is your kind of work that is being dealt with under the code. It is nothing but business restructuring, business reorganization, and insolvency resolution of corporate persons and also individuals. So, if there is any opportunity for any question answer or any queries, I'm here. I'll be able to, answer your questions. So let me now stop here. And once again, I wish all examination and wish you all a safe, secure, and be safe from COVID. Thank you.
Mr. Kumar, thank you very much for your address. You have been extremely clear in the way you propagated the code. I think the students have also noted that one of the very essential features of the code is everything is time bound here. That is very, very important. You spoke also about, that is a rewarding profession, undoubtedly. And you said that, you have to do business legally. These are the points I'm sure the students, will have to note as they go ahead. Mr. Kumar, you will be happy to note that more than 60% of the insolvency professionals are chartered accountants. And thank you for your kind words for the profession, which you have spoken just now. And regarding the quiz, since you have given the cadet of monetary award along with whatever you have given, and since they're all students of chartered accountancy, I'm sure you will get a very good response from them. And many of them, I wouldn't be surprised if some of them also goes on to win the award also. So it is very nice. Great. I was not aware of the quiz, but it's very nice that you have spoken about the quiz. I'm sure, the students who are listening to you would be, extremely excited to participate in the quiz. And since you will be here, I think any questions directed at you, we'll take it after Subodhji speaks.
Yes.
So once again, thank you. But we'll take the questions relating to any students having questions. As I said, we'll take later. The speaker for the evening, my student friends, is past President Subodh Kumar Agarwal. The first thing, we are both from Calcutta. So we know each other for years together. And today, the Director Board of Studies sent me the CV of both Subodhji as well as Mr. Kumar. Mr. Kumar's CV I was reading with a lot of interest. But then, since the CV of Subodh Kumar Agarwal also came with it, so I thought that I should also read that CV. So one thing that struck me was this, and this for the student, that he's an All India rank holder, in CA final examination. He stood 10th in the CA final examination. Very difficult to have a rank. So, to that extent, when he speaks, the students, please note that you are All India rank holder is addressing you. The fact that he is past president of the Institute of Chartered Accountants of India, that we all of us know, and he has been a very successful president. He has also been the president of South Asian Federation of Accountants. And I have seen him, post his presidentship, he went into Indias. Those of us, who are, very much inclined towards Indias, he went into Indias, and I could see him studying Indias, day in and day out. But once an opportunity of this insolvency and bankruptcy code came towards him, he grabbed this opportunity. And today he's one of the more successful insolvency professionals that we have. So with these words, may I now request past President of the Institute of Chartered Accountants of India, Subodh Kumar Agarwal ji, to kindly address the students. Subodh ji, please.
Thank you, Devashish ji, for your nice words. Since we are friends, students, I'll tell you, please don't go by, because being a friend, he is bound to speak good about me. And as he said, we belong from the same place, that is Kolkata. and fortunately, Sushil also belongs from the same place. Now, Mr. Saji, good afternoon, friends. Mr. Saji, we spoke in Kolkata again, in the Kolkata, in the income tax department, the lecture to the income tax department, which was very effective. And Mr. Saji Kumar, I found that it is a very good speaker. I loved speaking him, and I thought he will speak today, maybe for 15-20 minute time, but I don't know why he wants to give time to me. But probably in the end, we will have opportunity to listen to him along with the questions also. So, Bandana ji, Saji Kumar ji, Devasis, Sushil, Apurva ji, and other friends. Now it's time of COVID. But be it COVID or non-COVID, we as a professional, we know how to overcome everything. If it is COVID, it is non-COVID, we used to have a gathering of 200 people. But if it is COVID, we are having a gathering of more than 1,000. So this is the way we are overcoming the challenges. And that is the best quality with the chartered accountants. Friends, Mr. Tahu, who is the chairman of IBBI, he had said that the caregiver, the health worker and the caregiver has no excuse. Likewise, the insolvency professionals are the caregiver to the distress industry of the country, and they cannot have any excuses. In the last 3 to 4 months, that has been proved by the insolvency professional that be whatever situation, we will overcome. And since rightly said by my previous speakers, that out of the 100 people, around 60 are chartered accountants, but the other professional also, who includes cost accountant, company secretary, legal professionals, as well as management professionals. Everybody has, every members, every professional has come up to marks, and they have proven that this is the best profession, this is the noble profession, this is the profession which the country wants today the more. As we all know, when there is a difficult time, not only in India, but globally, and who can better understand the situation than the professionals, and the going to be professional would be professional, the FCA, Future Chartered Accountants. What is GDP? If we measure the economy of the country from the GDP, we know that the GDP, which used to be 5%, and we were projecting, and the Prime Minister of the country had given us a target to achieve $5 trillion by 2024. Now, it seems it has gone haywire. The GDP, when the COVID started, we were looking at a GDP of around 2%, brought it down to 1%. And my dear friends, you must have read in the newspaper, all the leading financial institutions, credit rating agencies, multinational agencies, they have projected the GDP maybe in the negative zone. That is the word, English word used, contraction, is going to be somewhere in 7 to 9%. Nobody knows what will happen, because still the projection says we have not reached the top of the COVID. The peak has not yet been reached. Every day, India is touching the new peak. Today we have crossed 11 lakh total number, but then recovery is also very good. I mean, number is increasing because this is a disease which is go on spreading. But if we learn how to live in the situation, then definitely we can control it. The kind of negativity it was there when we started our lockdown, somewhere in 23rd March, somewhere on 25th March, we're so scared. But today, we are not scared. Even if my neighbor, my next door neighbor, has a COVID, I'm not scared. Rather, today I'm trying to help him by making a distance. So likewise, the same thing is in a insolvency. Insolvency, why I gave an example of COVID, even though it's a global pandemic, we have overcome. And we are in the process of overcoming. And you must have read that the vaccine is under preparation. Now there are many medicines that has come up. Now the doctors are advising that unless and until you are critical, you don't have to go to the hospital. So likewise in the insolvency also, if we don't have to go to hospital, unless and until we are very critical. So how many people will be critical out of 1100? May not be 1 lakh also, may not be 50,000 also, may not be 10,000 also. That means others can be taken care by home quarantine. Likewise, in insolvency also, see if you have 5,000 cases, out of the 5,000 cases, those has been admitted in the under the NCLT, CRP process has commenced. Maybe out of 5,000, 100 are critical. If those 100 are critical, that has to be taken special care. And there will be a special kind of insolvency professional with the special team who will take it through to the non-disease, disease-free. But the others, by home quarantine, by the professional quality of the professional, the IP, the insolvency professional, the resolution professional, it can be taken care of. 14 days quarantine. So here, the 14 days has been converted into 180 days, which can be further after examination. The second test, the third test can be further extended to 90 days, that is 270 days, my dear friends. Now, this Insolvency and Bankruptcy Code, you must have read that is the biggest one of the biggest economic reforms in our country. Friends, it reminds me Albert Einstein, who said once, learn from study. What we learned in last 4 months, let us learn from last 4 months. The Subodh Kumar Agarwal, never used to be in the home after 10 o'clock in the morning and never used to come back before 9 o'clock. For 90 days, I stayed in my home and I am learning from there. I changed my lifestyle. Now it says, learn from yesterday, life for today, and hope for tomorrow. For all of you, I see a big hope in the Insolvency and Bankruptcy Code, my dear friends. Now, I'll take you through the PPT that I have prepared. I'm sure it will a little bit support you. It will help you in going through what my presentation will be. It will be in a systematic way. Now, Nayak, why I thought I'll give an example of Nayak, the picture Nayak. Probably all of you must have seen this picture. Anil Kapoor, I don't want to demonstrate that he's 65 years of age, but is still younger than Devasys Mitro. Maybe, probably, but Devasys Mitro is not 65 years of age. I want to demonstrate the story that is inside the Nayak. In Nayak, there was a story that he said that let me make one day chief minister. So here in one day chief minister, in the picture, not in the real life, he made drastic changes. He brought the state under control in one day. Under Insolvency and Bankruptcy Code, you are getting 180 days to bring the company of which you are going to be the CEO of the company, Chief Executive Officer of the company. Rightly said by Sri Saji Kumarji that you are becoming the CEO of the company. As a practicing chartered accountant, I never thought I'll be industrialist one day or I'll be executive of a big company because I wanted to be practiced. Today, I am practicing because I am a practicing resolution professional also. Side by side, I am also Chief Executive Officer of three big companies. It's not a small company. I have got a team. I am a Chief Executive Officer. That means I am working, I am earning side by side. I am learning also. Learning of three different industries with three different teams. Yes, I have to work by burning midnight oil. So today it's a only anecdote. It's not a midnight oil. Yes, we have to work hard. You have to work 16 hours. You have to work 18 hours. And as you say, there is no substitute for hard working. For your exam also, I always say, since Mr. Devasi said that I achieved in my life. If you look at my background, I am a Hindi speaking. I came from a Hindi medium and then I succeeded CA. That is only by sheer hard work. Even if you have a little bit less brain, but then if you are hardworking, the brain will come. The hard work will invite everybody and take into its own fold. So now, in insolvency and bankruptcy process, as a resolution process, you are going to be the Chief Minister of State. In turn, you are going to be the CEO, the Chief Executive Officer of the company for 180 days, which can be extended by another 90 days if the COC appoints. The Insolvency and Bankruptcy Code, Mr. Saji Kumar also said, the biggest advantage has been fiscal discipline. Fiscal discipline, the way the business need to be handled. Today, the moment this code is there, the distress is there, the company goes in the control of the professional, that is the insolvency professional. And now all the data that is required by the stakeholder, they get the symmetric data, they get the actual data. And that is the reason that under Insolvency and Bankruptcy Code, the fittest person will come back into the management. And the average realization, which used to be less than 25%, that also was average 4.5 years, has come down to, the realization has gone up to 46 to 50%. And you must have read in the newspaper, in some of the company like SR Steel, where the realization was more than 90%, which initially the bankers were not even expecting realization of 50%. That also a big company where the 50,000 crore amount was involved, and successfully the work has been done. So what is the driving point? What is the point which helped this legislation to be successful? Now, every stakeholder, everybody contributed, the government, the regulator, the judiciary, everybody contributed in the success of Insolvency and Bankruptcy Code. Now, if I'm talking about success, in Insolvency and Bankruptcy Code success, you look at, even in COVID time, it has not been stopped. It is going on. What has been stopped, you must have read in the newspaper, there is a stop of 6 months to 1 year for the insolvency and bankruptcy. It's not a stop. It is, I will come when I deliberate further what is the stoppage. It is not stopped at all. It is still going on. That is what I want to impress upon. Now, what was there before the IBC code came? Before the IBC code came, you must have read in your books that there was a different committee, SICA, Sikh Industrial Company Act was there. Then there is still RDD BFI. There was Surfacy Act, which is still there. So this act, though, came with much fanfare. All kind of facility were given to the promoters. Moratorium, the cool period was given, but still it could not be proved to be successful. Still, the country was looking at more and more distress. The country was facing more and more NPA. Then the present regime, the present government brought very quickly the Insolvency and Bankruptcy Code. The biggest character of this code is from debtors in possession. Debtors means the promoters. The control immediately shifts from promoters to the creditors, the lenders. Lenders appointed professional who is appointed by recommended by the lenders and who is appointed by the court. As such, the professional is also a court-appointed officers. Dear friends, and it was in 1st December 2016 when the court formally started operating. And if you look at, it is hardly 3.5 years, baby, where it has given the result to the country, and the NPA is drastically coming down. And it's not important that NPA has come down. The companies is not private property. It's not suppose I'm owning a company. It's not my property. It's the country's economic resource. The government gets revenue. The society gets employment. There are other industry, those who get dependent on the industry. So one industry impact many lives, impact many resources. That's why it's the country's economic resources. Now, in previous time, there were for individual insolvency, Presidency Towns Insolvency Act, and there were Provincial Insolvency Act. But have you heard this name? At least before the IBC came, I did not heard those names of those acts. It were since 1909, 1920. These acts are still there. It has not been repealed. It will be repealed only once the individual insolvency are notified in a full-fledged. As Mr. Saji Kumar said, individual insolvency has been notified only in a limited manner for those who have given guarantee to the corporate borrowers. Scenario, what was the scenario for resolution? Now, is this a resolution or this is a recovery? Mr. Saji Kumar said it's not a recovery mechanism. Why it's not a recovery mechanism? Because we don't want the company to close down. It's a resolution where the objective, I'll take you to the preamble of the code, where the objective is resolution, and resolution only. And only in case if it is not terminally ill, resolution is not possible, then it should go for the liquidation, no other choice. Now, what was the scenario before the Insolvency Code came? Previously, the formal was SICA, Sikh Industrial Company Act, totally failure. Informal was CDR, SDR, 4SA, S4A, CDR closed in 2015. It was not successful. SDR closed in 1 year. S4A, again, there was no result for the resolution by the bankers. For non-corporate, there was a compromise. And for individual, as I said, there were 2 acts, but none of us heard it. For creditors, they could have approached SURFACI. SURFACI, you could get the asset within 60 days. But again, you must have read many acts where it took to take possession years together. And there RDB FFI Act, there were civil law, but it were all taking time. Now post IBC, time is of the essence. Time is of the essence. 180 days. You must have heard it took 800 days. In one of my case, which I am doing, it is already more than 730 days. Resolution is there, but again, there are other issues. But does this mean that all the cases will take those time? We all know, friends, when you prepare a new house, when you buy a new car, there will be many problems. And when you drive the car, then you will find what are the difficulties. You go to the mechanic, you get it settled. Likewise, in case of insolvency and bankruptcy code also, you must have read and read in the newspaper, in the your books, etc. There has been multiple judicial precedents. Now, if you look at Supreme Court, the judgment has come in 15 days, in 20 days, in not more than 1 month. And there have been landmark judgments. One judgment settles 100 cases. I mean, there are issues which are settled by the one judgment. I'll give you an example which will be helping you also. Innovative Industries, the first judgment of the Supreme Court in case of the Insolvency and Bankruptcy Code. It was a landmark judgment which made many precedent. And now if you read the judgment, various judgment, you will find the innovative reference also. SR Steel judgment. It has settled many issues. Now, SR Steel judgment, it settled that if there is any dispute, any demand, that will be settled, that will be closed, and that will not remain for the new promoters. Swiss Ribbon, where the constitutional validity of the act was challenged, it also settled many issues. K. Sasidharan, which settled the issue that the stakeholder, committee of creditors, their commercial wisdom cannot be challenged. Now, Maharashtra Seamless, which settled the issue. All Supreme Court judgment will settle the issue that the commercial wisdom of the COC cannot be challenged, even if they sell the asset below liquidation value, the judiciary cannot challenge it. Synergy dure is the NCLAT judgment where the NCLAT settled the issue that even if it is government, the dues of the government, we have read throughout our life, the government dues will get first priority. But in this case, it was settled. No, government is an operational creditor, whether it is income tax or whatever, GST, it is operational creditor, and they will get the fifth priority as an operational creditor. If the resolution applicant has offered only 10% of the dues or 5% of the dues, and it is approved by the COC, and if it gets settled stamp of the judiciary, they have to accept it. And that is the reason that the IBBI was very kind to organize the program across the country for the income tax department to make them aware that don't be very rigid because you are the operational creditor. And ultimately, if the company revives, if the company survives, you will get back your money, not today, maybe after 5 years, maybe within the span of 5 years or 10 years. So friends, government contributed, judiciary contributed, regulators contributed, how the government contributed. Have you heard? This is in 3.5 years, there were 6 time changes in the Act. The Act, Insolvency and Bankruptcy Code was changed 6 times. 2017, 2018, 2019 2 times, and 2020 also 2 times the code has been changed. The regulation, if I talk about the regulation, I was just jotting down today for my preparation that in CIRP regulation got amended 13 times, 13 times. That means the regulator, the government is very receptive. Whenever they get any information, any comment, any suggestion that this is the practical difficulty in the implementation of the Act, they immediately take the stakeholders' opinion and sit there and with due diligence, the due process, they make the changes in the Act or the Act or in the regulations. So that is what. Friends, bankruptcy. Bankruptcy, this is my very pet slide and preferred slide, bumps bankruptcy. Bankruptcy is not a bad word. I am a person, Subodh Agarwal, I want to be an industrialist. I am a chartered accountant. That does not mean that I'll go for service. That does not mean that I have to do practice. That does not mean that I have to go for consultancy. I can set up my own industry. That means I am a risk taker. Country need people like risk taker, industrialists. If the industrialists would not have been there, the employment will not be there. The government, that's why always give incentive to the businessman, to the industrialist. If I ride the horse and if I fall down, am I wrong? No. You should salute me that yes, I had the guts to take risk. I took the risk. In the process, I fallen down. There is one gentleman, Bump. He's a very famous man. I will not say tell his right name. Today, he is one of the strongest person of the world. He faced bankruptcy 4 times. And every time, but he was a genuine person. He was an honest person. Every time, whenever he faced distress, I will not say the bankruptcy, distress, he went to the bankers, he went to the lenders, and then he sold his asset, gave to the lenders. He reduced his holding from 100% to 50% to 25% and to 5%. And today, maybe after facing 4 bankruptcy, he is one of the most strong person. It is a piece for you to identify who this Bump is. I will not name because it is on record. The record will be on the website also. That's why I will not name, but he's a very famous person. Now, preamble. It's very important, friends. You being a student, any act, when you read, please make it a habit to read the preamble very minutely, because all your act will be driven by the preamble, which is in the starting on the top of the this thing. What is preamble says? It's an act to consolidate and amend. It has consolidated many acts together, and wherever amendment was required, wherever conflict was there, amended that for reorganization and insolvency resolution. So what is the objective? Reorganization, resolution, not liquidation of some form in a time-bound manner. So again, within 180 days, within 270 days, time-bound manner for maximization of value of the asset so that the value increases, it does not decrease. My dear friends, even if you are able to stop the decrease, it is as good as increase. You must have read, you must have heard the paper ad that बिजली बचाना बिजली उत्पादन करने के बराबर है, and to promote entrepreneurship and availability of the credit. And then the biggest reform is alteration in the order of priority of payment. The government payment, which used to be number 1, has now been brought down to 5th. What is waterfall mechanism? During my deliberation, I'll let you know what is waterfall mechanism. Friends, one more question, which I will answer. Why it is called code? Preamble of the code. Code is what? It is act. It is act. It is code is nothing. But why the name has been given? I give the example of Raymond's. You must have Raymond's heard the name advertisement Raymond. Raymond, that cloth shop where you buy. Most of you buy. Why I equate with the Raymond? In Raymond, you must have said a complete man. When you go inside the Raymond, you go without clothes. When you will come out, you will have a underwear, underpant, pant shirt, socks, handkerchief, watch, tie, everything you will have. So you will a complete man. In this code, in this act, all the act has been brought at one place so that it goes with, it's like a driving on a Yamuna expressway from Delhi to Mathura or Delhi to Agra, where none of the road, the junction can disturb you. You can drive at 100%, 100 speed, not at 150 because that is restricted. So you can drive at 100 and you will reach safe. You are safely driving. That's why it is called code. Dear friends, I will not go on structure. The structure is there in the act itself. It has been divided in 5 parts. The ecosystem. Now, ecosystem, you see, who are the players? Who are the players in this code? The players are IBBI. These are the part of the ecosystem. That means IBBI is the regulator. I'll give the example. I'll equate who is the regulator. For your profession, you are the student. I am the chartered accountant. Who is my regulator? My regulator is the Institute of Chartered Accountant of India. My regulator is not Government of India. Government of India is the central government. But my regulator is ICAI. Likewise, for the insolvency professional or for those all entities, those who are involved in the insolvency process, IBBI is the regulator. Now, below that, there are IPA. IPA means below second level of regulator. I can say second level of a regulator, that is Insolvency Professional Agency. Now, there are 3 insolvency professional agency: Chartered Accountant Institute, Costing Institute, and Company Secretary Institute. I will not go into detail because Devashish Mitro had also talked about that. IU, now in information utility. Now, all the information is required to be put in the IU, and then there is a court which is called adjudicating authority or insolvency resolution process of the corporate. NCLT, National Company Law Tribunal, is the adjudicating authority. If you look at from the hierarchy, it will be below the court, but they are the tribunal. NCLT is the appellate, first appellate, and Supreme Court is the second appellate. Friends, this is very important to understand how the COC and the process works. If you look at operational creditors, now for committee meeting, they are in the standing position. Operational creditors, they are standing positions. Financial creditors, see, they are sitting and they are discussing. Now there is a meeting going on, the third slide, where there are 2 rows. Now in the first row, only financial creditor can sit. That means they are the member. They are the member. In the second row, there are other participants who cannot be member, who are only called participant, who can't cast vote. So there, if operational creditors are having more than 10% of the total debt, they can sit here. Or directors of the company, they can sit there. So only those persons who are defined in the Act and Regulation those who can participate, they can sit on the back. They cannot be voter. They can only be the participant and they can contribute. Now, suppose in any company, if the financial creditors are not there, then who will be sitting on the front row? If the financial creditors, friends, then top 18 operational creditors plus one representative of the employee will be sitting as a COC. Now there is a insolvent and bankrupt. Now I'll go very quickly because I'm finding that it is already 4:55. It applies to the whole of India. By amendment, the part 3 was not applicable to J&K, but in March 2020, the amendment was made. Now the IBC code is applicable to the whole country, including Jammu and Kashmir. On whom it is applicable? Companies governed by a special act, LLP, partnership firm, and individual. Now, with amendment in December 2019, it is also applicable on certain financial services provider, and that is the reason that Diwan Housing Finance Limited is now under CIRP because of this amendment. Now we'll go to what is insolvency and resolution process and liquidation process. Friends, the definitions are there in section 3, section 5. I'll not go through the definitions, but I'll request you that whenever you read definition, please see it. The definition section start with the words, in this code, unless and until the context otherwise required. So when you read the definition, you need to read the definition along with the applicable sections. So definition you cannot read in isolation. Always read the definition along with that particular section where that words are used. Then only you can derive the exact meaning. The important words are initiation date, insolvency commencement date, financial creditor, dispute. In case of the operational creditors, the dispute word is very important, and the Supreme Court, in case of Mobilux cases, has settled the dispute. Operational date, financial date. So now in financial date also there have been many NCLT decisions that what constitute the financial date. Even though the definition is very exhaustive and the simple definition says that any money lent cannot be, only money lent cannot be financial date. Unless and until there is time value of money, that means interest is there. But then there are other sub-limb of the definition. One must read the full definition, and then you need to read along with judicial precedent to understand what is the exact meaning of the financial date. Resolution professional, related party. Now, related party is very important when you go for anything. Related party, even in the Companies Act, but for the purpose of Insolvency and Bankruptcy Code, there is a separate related party definition under section 5 subsection 24 and also section 5 subsection 24 capital A. There are two definitions. Now, what is the insolvency resolution process period? Who is resolution applicant? And then, friends, in the code, when you read the code, you will find two words every time in every section coming up as prescribed, as specified. Please remember, the moment they say as prescribed, that means it will be covered in the rules. It will be notified by the central government. And if it is mentioned as specified, that means it will be under regulation, and regulation is prepared and notified by the Insolvency and Bankruptcy Code of India. Now, in very short, I'll share with you what is corporate insolvency resolution process. Now there need to be default. Default of either principal or interest or both. And the default must be more than 1 crore rupees. Previously it was only 1 lakh rupees, but due to COVID, due to the committee suggestions also, the amount has been, section 4 has been amended, the amount has been brought up to 1 crore. So if there is a default is more than 1 crore, the petition can be filed in the NCLT to start the corporate insolvency resolution process under IBC. Who can file the application? There are three kinds of application that can be filed. Financial creditor under Section 7, operational creditor under Section 9, and the company which is in distress itself, that is Section 10. For the time being, as I was saying, that there has been a stop on the IBC process. So not IBC process per se, the entire process. Only in those IBC process, Section 10 capital A has been introduced, whereby the default which occurred from 25th March 2020 and onward. If the default has occurred on 24th March or before that, I can still file the petition under Section 7, 9 or 10. So my dear friends, most of the cases where the company is in distress, the default has already occurred. And if the default has already occurred, now there is no stoppage in the CIRP process. I mean, it's a very important point where you as a student must need to understand, and then you can propagate it. And also because you all are going to participate in the quiz contest where you will be getting 1 lakh rupee, 50,000 rupees, 10,000 rupees. As Devasis said, for chartered accountant, the student also understand the money, the figures. But my dear friends, there the recognition is very important. Getting gold certificate, getting bronze certificate, getting silver certificate is also equally important. And as Mr. Saji said, I'm very happy to note, but Mr. Saji has made me ineligible to participate in the quiz contest because I am supposed to be knowing the act. So if I can bet you, if you read 7 days this act, you can be much more learned than me. Dear friends, I recollect one incident where Devasis was also there. Mr. Sahu, the chairman of IBBI, me and Devasis, we were in Guwahati to deliver a lecture where I told Mr. Sahu that it is good that you had a cooling period of 10 years to pass the exam. If I pass the exam in second attempt, if the youngsters go, they will pass in one attempt by study of the 7 days. So you are much more, your grasping capacity, your memory is much better than me. So I can bet, and you can bet with me. I will give my email ID. My email ID is there in the PPT also. That if you read 7 days, I can bet that you will be eligible to get even the gold certificate. Gold certificate, leave apart money, and then they are going to give the participation certificate to each and everybody. In fact, in my office, I'll encourage all my articles, etc., to participate, and I'm sure that institute is also going to propagate that. Now, the moment it is filed with the NCLT, the petition, IRP is appointed. IRP can be only insolvency professional who has to be registered with the IBBI, Insolvency and Bankruptcy Board of India, and who has to be enrolled as a member with some of the IPA. Like I am enrolled with the Institute of Chartered Accountant of India IPA, Triple IP, ICAI. Now, once the insolvency start, my clock start ticking. 180 days, not beyond that. And my target is to complete the process in 180 days. Within next 14 days, I have to collect the claim by announcement in the newspaper. I mean, everything is defined. You don't have to put your mind. You just read meticulously, make a chart. If you prepare a chart, you can jot down. And moreover, Regulation 40 capital A, the timeline is given. You have to put in the checklist so that nothing you misses. Next 7 days, verify the claim. Next 2 days, form the committee. Next 7 days, within 30 days, have the first COC meeting. And the IRP job is over. If IRP is appointed as RP, he will continue. If it does not, he is not appointed as a committee RP, some other professional, but the work will not stop for a single minute. The work will continue. The process will continue. The 180 days will not stop for a single day. So appointment of RP, my dear friends, there is a moratorium. What is moratorium? Cooling period. That means I will resolve. No outsider can disturb me. No lender can come and disturb me, give me my money. Nobody can file a case against me. I can file the case so that I can sit silently, try to resolve with whatever assets are there, and then for everything, the committee of creditors will take a decision. RP is only a process driver, but he will chair the meeting. He is the CEO of the company. He has to ensure that the company runs as a going concern. If the company has any difficulty and it is fault of the IRP, he will be pulled up by the IBBI. The COC, for most of the decisions, it will be taken by 66%, some of the decision with 50%, and some of the decision with 90% value of the vote. And the value will be decided not on number, it is on the total amount outstanding. If 100 rupees is total amount outstanding, and the ABC Company Private Bank Limited has 51 rupees, his vote will be 51%. Those having 10 rupees 95 paisa outstanding, his vote will be 10.9% of the total 100 rupees. So the process will be, now this process is given here in the flow chart. Moratorium shall probate, it's a cool period. RP shall prepare information memorandum about the company. Appoint valuer. Publish the information that the company is under resolution, and whosoever wants to come, participate as applicant can come. Identify the prospective resolution applicant that who wants to come and get the management. Allow access of all the information to PRA, I call prospective resolution applicant. All documents. The PRA will submit the resolution plan. RP will evaluate, present before COC. Now, which is compliant plan under section 29A, section 30 subsection 2, it will be put before COC, and then COC will look at it, and if COC found feasible and viable, after negotiation, if they are satisfied, they will vote on the plan. If the plan gets 66% of the votes, the plan is presumed to be approved. If it gets less than 66% vote, it is presumed to be rejected. And if it is approved, it goes to NCLT for approval of the plan. If it is rejected, it goes to the NCLT for liquidation of the company. In this process, as I said, the objective is resolution, resolution, resolution. But if the resolution does not happen, it is dissolution, it is a liquidation, liquidation, and liquidation. But of late, my dear friends, even in the liquidation, the court has come out with the going concern sale of the concern, and under section 230 of the Companies Act, it has been allowed, and also under section regulation 32A, E and F, the going concern sale has been allowed, which is as good as resolution where assets are sold and not the liability. Friends, there is also fast track insolvency where smaller companies can be resolved within 90 days, which can be extended by 45 days. And also the timelines, I have put it here in the chart. I am not reading it because I have shared with you everything, and there is regulation capital 40 capital A of CIRP regulation where everything is given, so you can look at it. Friends, we have already discussed this. Now I am going to, duty of the RP is everything. RP is responsible, accountable, and duty bound to do everything for the successful resolution of the company with the approval of the COC. Now, for everything, it need not go to the COC. There are inherent power and duty which RP need to go, and IBBI is very clear where the RP has got inherent power and he approaches the COC, he will be taken to task because he need to identify what is his duty, and if he try to put it on the soldier of the COC, he is subject to pulling down by the by the IBBI. Friends, as we have already discussed section 30, section 31. Now fast track, I will only share with you small companies whose paid up capital is up to 50 lakhs. turnover is up to 2 crore, or borrowing is up to 50 lakhs. That is called a small company under section 285 of the Companies Act. Or startups which are up to 5 years and turnover is up to 25 crores. They are eligible to go under fast track process, which is under section 55 till section 58 of the Insolvency and Bankruptcy Code. Now we will quickly go to the liquidation. Liquidation is from section 33 till section 54. Friends, the timelines. There is a strict timelines. Within 1 year, the liquidation has to be completed. So strict timelines are there, are not going to the timelines. The process. Once resolution fails, liquidation start. The NCLT will pronounce, the commencement will be from the date of the pronouncement by the NCLT. Ad has to be given for collection of the claim within 30 days, the verification within next 30 days, and then the things has to be done, and then the process has to be completed. So I put it in the liquidation process in the flow chart. Now, the thing will come under control of the liquidator. Now here, the professional is called liquidator. All the asset will come under the liquidation state. The liquidator is treated as a quasi-judicial authority. He has the power of the, not quasi-judicial authority, but he has the power of the quasi-judicial authority. In case of the resolution professional, if the claim comes, he can only accept, but he is not the final authority. If somebody is not happy, he need to go to the AA, executing authority. Whereas in case of the liquidation, his power is as good as executing authority. Friends, the liquidator or the resolution professionals, they also need to, within 75 days, they need to find out whether there are any transactions which are avoidable, which are called preferential transaction, undervalue transaction, transaction for defrauding the creditors, extortionist transaction, which are imbibed in section 43 till section 51. And also there are two more sections, 66 and 67 for transaction, fraudulent transactions, where it is the duty of the professional to identify and approach the court. There, they need not get the consent of the COC, Committee of Creditors, for identifying and going to the court. It is the duty of the professional. Even if the COC says, no, you did not go to the court, then if it does not go, he will be pulled by the regulator, by the adjudicating authority. Now, friends, secured creditors, unsecured creditors, there are different privileges. Secured creditors under section 52, he can take, if it is liquidation, he can relinquish his asset. He may not relinquish his asset. He can sell the asset. Now, and then there is finally section 53, that is waterfall mechanism. Here, as I was discussing with you initially, the government priority is on the 5th position. Under waterfall mechanism, the first priority is CRP cost, corporate insolvency resolution process cost. Second is secured creditor and 24 months of the wages. Third is 12 months of the salary. Fourth is unsecured financial creditor. Fifth is the government dues and operational creditors. So how it works? Secured workman dues, insolvency CRP cost. Second is secured workman dues. Third is wages for 12 months. Salary of 12 months. Fourth is unsecured creditor, financial creditor. Fifth is dues to the state government, central government, and unrealized secured creditor. And sixth is other operational creditors. And next is preferential shareholder, and thereafter equity shareholders. What is waterfall mechanism? Why it is called waterfall mechanism? My dear friends, it is called waterfall mechanism. That say there is 100 rupees after sale of the company, and the dues of the CRP cost is 50 rupees. So first 50 rupees will be paid to the CRP cost. Now it will come to the secured creditor, the second priority. The second priority is 200 rupees. Now the second priority will get only 50 rupees in the proportion to 200 rupees. Now the third priority is 4th, 5th, 6th will not get anything. That is why it is called CIRP. Now friends, we'll quickly go to the voluntary liquidation. Section 59, only one section. Voluntarily, if somebody wants to go, if the company is solvent, has not defaulted, majority of the directors give a certificate, decide, have a AGM or EGM within 4 weeks of decision, voluntary liquidation can be done. Friends, opportunity for chartered accountant. Devasis said, I am a practicing chartered accountant. I was practicing for the Indian accounting standard. Suddenly one fine morning I found IBC has been promulgated. On 25th Jan 2017, some of the bankers told me, Mr. Agarwal, do you do insolvency? I said, sir, no, I have written one article. No, we have some assignment. Are you interested? I said, fine, sir, I will meet you after 1 week. That day itself, I went, registered for the exam. 25th, 30th, I appeared in the exam. I failed. Yes, I failed. I got 57.5 marks in reading of 5 days. The next thing I did, when I came back, the first thing I did, registered for the next exam, I got 3rd February. I appeared in the exam, I got 62.5%. Perseverance, follow up, PA exam, only perseverance, hard work, follow up. If you have this quality, nobody can stop you from passing this CA exam. Nobody can stop you from pursuing anything which you want. In three years, yes, I am one of the professional who is fully in the insolvency. My office may be doing something else. No, 10 years qualification, pass the exam, but then not needed 10 years. Mr. Saji Kumar, who is the authority, he said, even after graduation, go for the special exam. I mean, graduate insolvency, and pass the exam immediately. You can be as equal to me, Subodh Agrawal. Even if I am having 30 years of experience, you with 2 years of experience, you can be insolvency professional. You can be an insolvency professional of SR still like company also. But then you need to have a 50 hours of registration also. The opportunity, you can be IRP, you can be resolution professional, you can be liquidator, you can be representative of in the committee of creditors, that means consultant, you can be representative of the class of creditors, that is for the real estate or where huge fixed deposits are there. You can be voluntary liquidator, you can be resolution professional for individual, partnership, proprietorship, is still not notified, but in the limited way, it has been notified for those who have given guarantee for the corporates, bankruptcy trustee, that is in the liquidation, promote an insolvency professional entity, a company which the CA issued also allow you to have a corporate entity. And moreover, my dear friends, not it limits here. Even the Securities and Exchange Board of India is appointing the administrator to the insolvency professional only, thanks to the IBBI that they marketed it and they got it done. I am also administrator in one of the chit fund company where you need to locate the asset, identify and sell it. I mean, you are doing a human's job, my dear friends. It's not a profession. It's a service to the nation. If you are able to revive a company, if you can contribute to revive a company, the satisfaction level you have a great. Yes, I revived. I was the insolvency professional where the company which was at the deathbed could be revived. Advisor, recovery of business debtors, support services, transaction auditor, now forensic auditor and transaction auditor. You can become a registered valuer with 3 years of experience and you can be consultant. Friends, please, don't take it very hard. Take it very easy. And as I said, I can bet you, if you read the code, the regulation for 5 to 7 days, you all will be winner. At least it will be very difficult. Only 3% can be on top 3: gold, silver, and other. But then bronze, only 3%. Money, only 3%. Money is not important. But you as a chartered accountant student, if you get it, please inform to the Devashish Mitra and Sushil Goyal that yes, we participated. And I request all of you, please, once you participate, intimate to both of them and Bandha Nagpal also. Because your information will go to IBPI, but intimate to issue that yes, we have participated, it was our duty. And side by side, our knowledge has increased, and this knowledge, we are going for the support of the insolvency professionals, which has a huge opportunity in days to come. My dear friends, thank you very much for a patience hearing. Thank you.
Thank you, Subodhji. If I would have been a student, and if I would have been appearing for the final year exam, and if I would have heard Mr. Saji Kumar and Subodh Kumar Agarwal speak in only about 1.5 hours or 1 hour 20 minutes, the way you have covered the insolvency code, I would have thought that I am extremely lucky. And I think those students who have listened to both Mr. Kumar and Mr. Agarwal, I'm sure you will agree with me that we have been very much enlightened by the deliberations that they had. Extremely enlightening deliberations both by Mr. Kumar and Mr. Agarwal. Two slides which Subodhji had shown us, and which is very much in my mind. One was on the way the committee of creditors meeting and the financial creditors sitting in the front row. Those of us who have seen that slide will not miss the fact that financial creditors, they always sit in the front row. And the second one was on the corporate resolution process, the way the process goes. If those two slides are there, if that is there in your mind, I think it will be very simple for you to understand this code. Mr. Kumar, in his address, he was telling us about time bounds. Modi has said 180 days plus 90, and fast track 90 days. So there's this time limit. Both of them might have given you a very rosy picture of things, but let me also tell you, it is also a high pressure job because of the time limit that is there. It's quite a high pressure job. So that is very, very important. He was telling us about waterfall mechanism, section 53. Those of us who could not have a haircut because of COVID, this code also, refers to haircut. For example, a bank, which has, to which 100 rupees was to be paid. If the bank says that I'm agreeable to take 50 rupees, the difference of 50 is the haircut that the bank takes. Subodhji has told us about resolution, and resolution. I will not take the later part, liquidation, but it's all about resolution. It is all about resolution. And two small points. He spoke to us and he told us about perseverance, about sincerity. I think these are the words the students must take to their heart. You have to be extremely sincere to the course, and that is the way how you will pass the exam. Passing CA exam is not a very, very difficult exercise. And the last one, and the quiz one, which Mr. Kumar and Mr. Agarwal, both of them have propagated. But when I spoke at the beginning, I said that it's 1 lakh or 50,000. Subodhji had said that it's not only 1 lakh and 50,000. It is the recognition, the reputation. Those are the important things that should work in your mind. The recognition, that somebody pats you on your back and says, look, your knowledge has been excellent. And I think, that satisfaction is much more than the money that you earn. If somebody tells you that you have got an excellent reputation, that is what it is. So thank you very much, both Mr. Kumar and Agarwalji, for having, really enlightened us. Now, Sushil, would you are there any questions, Sushil? Now it is up to you.
Yes, sir. Yes, sir. Number of questions are there. Number of students wanted to know about
If I can intervene just for a few seconds, Mr. Goyal, before we start answering questions, I wanted to introduce a chartered accountant to you because just to inspire the prospective chartered accountants, the students here. I have a chartered accountant, a young professional who is working with me. He is Mr. Rakhav Maheshwari. He's right here. Of course, he has logged on from Mr. Ramachandra Rao's system. I just want to, he's a chartered accountant. He practiced for some time and then joined IBBI as an assistant manager. He is one of the first cadre of the Insolvency and Bankruptcy Board of India. We have 18, 19 people, young professionals chartered accountants, lawyers, cost accountants who have joined. They are the assets of the Insolvency and Bankruptcy Board of India. I just want to introduce him. He's actually tirelessly worked for the quiz. I just want to invite him and to talk, for 2 minutes on the quiz. And this is an inspiration for all the prospective chartered accountants. Over to you, Rakho, please.
Thank you, sir. Thanks a lot for kind words. Thank you, Subodh, sir, for a very nice presentation. We always look forward to your presentations. And with this, good evening, friends. So you all have heard from Saji sir and Subodh sir about the quiz. I would just like to mention in brief that how you can register for the quiz, how you can take up for the quiz. I'll show you the manner in which you can register for the quiz. It's a very small process. It's a 10-minute quiz. You can take it from anywhere. While viewing this video also, you can use your mobile phone, tablets or your laptops to register for the quiz. I will just share my screen and show you how you can register for the quiz. So, is my screen visible? So this is the website of ICAI. You all know this very well. So ICAI has uploaded the details of the quiz on their home page. You can go to this home page and simply click here to read more about the quiz. Here you will get the complete brochure of the quiz, and you will be able to see you will get the link for going directly to this page. This is the page of MyGov portal. MyGov is the Government of India's official citizen engagement portal, and from your ICAI website, or you can also use the IBBI website, www.ibbi.gov.in. So either ICAI website or IBBI website. This website will give you the link to the MyGov portal. At MyGov portal, here you will find the section for registering for the quiz. You all might be having Facebook account, Twitter account, Instagram account, LinkedIn accounts. You can use any of them. So you can register with your mobile number, your email ID, your Facebook account, your Twitter account, your Instagram account, anything. It's hardly a 1 minute process. You can register for the quiz. You all have read Insolvency and Bankruptcy Code. It is, if you want to see the sample questions to judge the difficulty level of the quiz, on this MyGov page, you will find the sample questions also. The sample questions are also available on the ICAI website also. If you click the link at ICAI website, you will also see the complete brochure of the quiz. You will be able to see the sample questions, and the quiz comprises of 20 questions and you will be given 10 minutes. And I would like to mention here that from last year, ICAI has changed the pattern of CA final examinations, and 30 marks objective type questions have been introduced. And corporate and allied laws is one of the paper in which they ask objective type questions. So you all know that the exams have been deferred till November because of COVID. So this quiz will act like a mock paper for you to appear for the CA final examinations. So this quiz will help you not only to prepare yourself for the CA final examination, it will give you an insight which will help you in clearing examinations as well as taking on the opportunities available in the professional world as a IP and the other roles which the Subodh sir has highlighted. So just use your any social media account, log in, go to the ICAI website, go to the IBBI website, register for the quiz, and I wish you all the best. And I wish that as the ICAI has given the largest number of insolvency professionals, we will get the largest number of winners from the ICAI. Thanks a lot.
Raghav, one query. How many times I can appear for the quiz? Suppose I am appearing, though I am not eligible, but yes, how many can I appear as many times as I wish?
No, sir, only once a time, because, and it's only a one-time thing. If you can register only once.
Mr. Maheshwari, thank you very much. We would also like to take this opportunity to thank Mr. Apurva Agarwal, the CGM of Insolvency and Bankruptcy Board of India. He was the one who initiated this whole program. So, Mr. Agarwal, thank you very much. Mr. Maheshwari, thanks once again. And now may I request Sushil Goel to kindly take over. Sushil, please.
Sir, the mainly questions were regarding this graduation program. Sajid sir had told about that. All the students are taking interest in that graduation program. And second part of the quiz, so I think the queries related to quiz is now clear. We have told everything, how to go for the quiz and how much time it is required. Everything is now explained to them. So please, if you can elaborate on this graduation program for insolvency.
Yeah, sure. I'm very happy. In fact, I'm sure that Mr. Subodh Kumar Agarwal will not, be angry with me if I explain it, because if I say that the idea of IBBI is to catch the young professionals, right? I mean, I'm sure that he will not be angry, because he is a person who encourages young people. The idea is, to have insolvency young professionals who do not have experience. Of course, experience makes a person perfect, but what we do, we give a comprehensive training for a person to become an insolvency professional. Of course, we choose professionals, young graduates, young, chartered accountants, young lawyers, so that we can train them, in 1 year in a classroom circumstance, and the next year on-the-job practical training, and then they will be able to take the limited insolvency examination, which is the same examination that the 10-year experienced chartered accountant or other person takes. And then he or she can, enroll with an insolvency professional agency. And then a 50-hour registration course, and then to register as an insolvency professional with the IBBI. Not that you will be able to work only as insolvency professional, as rightly put by Mr. Subodh Agarwal. Your services can be utilized in support services of insolvency professionals. I'm sure first batch of the course, is just going to end, and the second batch, the selection has already done. This is conducted by the Indian Institute of Corporate Affairs, which is an autonomous body under the Ministry of Corporate Affairs, Government of India. They have a campus, beautiful campus in about 40 kilometers from Delhi. It's a place called Manesar in Gurgaon, near Gurgaon in Haryana. They have very good campus and very good library and other research, equipments and stuff. Good faculty. It's a residential course. And there is an entrance examination which is conducted by ICAI, and through the entrance examination, online entrance examination, students are chosen. This year, the second batch selection is just over and the classes have begun. You'll be able to apply for this, and if you get admission through the entrance examination, you will be able to join as a graduate insolvency program student. And there are a lot of opportunities. We have just seen the first batch after they finished their, theoretical classes. All of them, all the 39 of them have got placement. Then, in a sense, they are working with insolvency and other organizations, and they are getting, around 1 lakh rupees as stipend in the beginning. This is a very rewarding profession. And even GIP is also showing good results. So we encourage young chartered accountants also to come to this field.
Sir, they want to know how you see the future of IPs in India.
I mean, there is a bright future for IPs in India, in the sense that so long as insolvency and bankruptcy code is there, IPs are going to be there. So long as business is going to be there in India, IBC is going to be there. There is no question of living without business. If there is no business, there is no life. There is no economy, right? It is not only jobs that would give employment. It is the business that generates employment. It's a trade, a business, commerce, and so long as this is there, insolvency code will be there. The insolvency professional will be there. There is absolutely no doubt about it.
Sir, one more question is coming, that is whether there is any age limit for this graduation program of IBC?
The age limit, I think now it is 27 or 28 years, but you are all, most of you must be eligible for this.
Okay. Next question I want to put to Subodh Agarwal ji. Sir, in what way IBC code is different from SURFACY Act 2002?
It's totally different. SURFACY, I had during my deliberation also, I told, though SURFACY came with much bang, when SURFACY came, people were very happy that with 60 days notice, you can take possession of the proper asset of the company. The basic difference is SURFACY is a recovery. SURFACY, it is a recovery. I'm recovering the asset, selling it. That means I'm killing the bird. I'm killing the bird. It will not give more eggs in the future. Whereas in insolvency, my objective is to resolution. I'm not selling the asset. I'll give example. In one of the cases in Bombay NCLT, the resolution was passed with 82% of the value of the vote, and which was rejected by the NCLT. The reason being, in the resolution plan, it was written the resolution applicant will be suing the company after 3 years, and it was approved by the. So here the objective is to the new management, the new resolution applicant has to carry on the company. As I said, when me, Sajid Kumarji and other, we went through the income tax department, what we told, what we propagated, that today your outstanding is 100 rupees. You are getting only 10 rupees or say 1 rupee out of the 100 rupees. Don't be disheartened. If the company survives, revives, employment will come, 1,000 people will be getting employment, new capital will come, again, the chimney will start, again, you will start listening the siren of the chimney, and it will make money. If they make money, government will get the revenue, excise, GST, and the income tax. Probably after 5 years, you will get 500 rupees instead of the 100 rupees, which you took a haircut. Because it was talking about the haircut, I was wondering, my hair is totally cut. But then, I am not worried. Even if it is haircut, I am giving a lecture. I am learning. Since today morning, I gave full time for learning. Then only I came for giving the lecture. So, it is totally different. That is a recovery. Ours is a resolution. It is much more the objective. That is not a time bound. Though the objective was time bound within 60 days, but now it is taking 8 years, 9 years, 3 years. Here, initially, you cannot give example of SR still 830 days. Now, because that is said the landmark judgment, giving the XR stay, now I am saying no further people can come and ask money, because the Supreme Court said it will like become Hydra head propping up. No, Hydra head propping up cannot be allowed. Stop. If got the company resolved at 500 rupees, even 200 rupees is outstanding, he did not participate, he did not file a claim, nothing due. Everything is exhausted. I am getting a company totally clean. You must have heard. Section 32 capital A has been introduced. GSW, the resolution of Bhutan Power and Steel, the PMA, the EDK. This is the no. The asset bound was 5,000 crore. Supreme Court said nothing doing. You go, file the claim, take action against the asphalt promoter, not against he is the new resolution applicant. So it's totally different. So new code is laudable.
Sir, next question.
Mr. Saju, it's a very important question, so I would like his comment also.
Saji sir, do you like to comment on this? How it is different from?
No, Mr. Agarwal has put it very nicely. I don't have anything to add.
So next question coming to you, sir. My question is about recent proposal of government of bad bank. Will it have any special role under IBC?
Bad
and
bank?
How it will helpful more for resolving stress account?
You're talking about bad bank?
Yes, sir. The question is for bad bank. I am not talking, sir. The question somebody asked about the bad bank. I also first time hearing this bad bank word.
I didn't quite get the question.
So what, sir, you were...
The bad bank proposal is going on. Sajiji, if you recollect, sometime in June, July 2019 also, the government had come out with some kind of proposal whereby the bad asset will be taken over and they will leverage it. So it will be put at one place. So it is that only. Yeah, over to Sajiji.
It's I think ARC they were talking about, right?
Improvised version of ARC. Improvised version of ARC.
I got it. Of course, I am not in a position to comment on it because it's a proposal of the government. I don't know at what level it is being considered. Of course, IBBI, as IBBI, we have nothing to do with that, right? So I will not be able to comment on it.
Sushilji, I will just like to add that bad bank proposal is coming out. Again, every new thing is required to be tested. In our country, though insolvency code when it came, people used to say that SURFACE, RDB, FFI, it came with bang and it failed. So people were not very optimistic. They were more pessimistic about IBC code. But in last 3.5 years, it has been proved. If the leadership is strong, if they are adaptable, if they don't mind changing, they don't feel it, take it at ego, that no, it was there some mistake was there. They are ready to correct it. As I said, the act has been changed 6 times and the regulation has been changed 13 times. Likewise, whatever comes in India, we have a pool of young people, we have a pool of professionals. So everything, if it comes, it will be successful. And if the government and regulators bring, they will bring after due deliberations, and I'm sure it is going to be successful. And one more thing I would like to add, Saji Kumar ji rightly said, अगर आप घोड़े पे चढ़ोगे तो गिरोगे, आप बिजनेस करोगे तो लॉस भी करोगे. कोई ऐसा धंधा नहीं हो सकता है. How much smart you may be, if you who knew that COVID-19, I can tell you, Saji Kumar ji, one company I'm handling where before COVID, my profit was 1 crore rupees per month. After COVID, my loss is 3 crore rupees per month. Who can visualize that suddenly you will be in total soup? It's a business, it's a risk. That's why I always propagate the businessman, if he has not done malfeasance or fraud and he has fallen, please salute him for the risk taking. Now over to Sufilji.
Thank you, sir, for answering this question. One question is coming. I probably consider it will be last question. We have to close the session also. Sir, if a company is incurring loss and company is not having profit, how they will pay the remuneration to this side? These professionals, IPs.
Haji, this question is for Haji Kumar.
That's the reason why company is into insolvency. The company was not in a position to pay its debt. Right now, it is 1 crore rupees. It was 1 lakh rupees earlier. So that's the reason the company has come into insolvency. So the insolvency professional, when he takes over, in fact, we have seen in many cases, after the insolvency professional has taken over, the management and control of the assets of the corporate debtor, the company in trouble. In fact, the company started making profits coming back into fees, right? Because the insolvency professional is a professional who would first check, pilferage. So there are many reasons for a failure of a company, because if he checks pilferage of money, or assets going elsewhere, that itself would give an opportunity to bring back the company into wheels. Then there are mismanagement issues. There are misgivings. The erstwhile management did not conduct the business of the corporate debtor properly. That's why, and that's how the company is into this. And the expenses, of course, incurred in the corporate insolvency resolution process, that is including his fees, it is included in the process cost fees, right? And that cost gets priority in payment, in resolution as well as in liquidation, right? So you have to pay the professional. There is no question, because the professional has dedicated his 180 days plus 90 days, or maybe 330 days now. He has dedicated, and he has earmarked that time for the reorganization of the corporate debtor. And since he is doing his job, his fees, the costs of incurred by other professionals, they have to be borne out of the cost of the process. So that has to be there. If there is no chance even for payment of process cost, the chances of revival is very bleak. The company will only go into liquidation, and the company can only be sold in parcels and bits, and then whoever is eligible will be able to take whatever is available.
Can I add here something?
Yes, sir, please.
Yeah, Sajid, I just add on what Sajidji has said. The IP should not be worried. Even if the company is not generating money, suppose it's a closed down company, it's not generating company, there has been innumerable judgment of the NCLT, whereby NCLT has directed the cost. So in some of the cases, maybe you will be waiting till resolution happens, or you will be waiting till the liquidation process completes. But in most of the cases nowadays, there is a direction of the NCLT. The moment you approach the NCLT is giving direction to the COC to share the insolvency resolution cost, so that there is no hurdle in the CRP. So the students should not be worried about the money part. That is number one, in a fixed deposit. First priority, fixed deposit. Number two, if you have a patent, the fee is very good in the insolvency process, and you will be getting the fee maybe 1 or 2 or 3 months delayed, but you will be getting it.
Thank you, sir.
ICAI is charging their 0.25% on accrual basis, well knowing that in many cases the money is coming after 1 or 2 or 3 years also. Since ED Sajid Kumarji is there, so they can put before the board that their money should be realized based on the realization basis, not on the basis of the accrual basis. This is my submission to the ICAI.
Okay, good suggestion. Yeah.
So over to chairman for concluding remark. I think it's time to close the session.
I think we have had an excellent session. I reiterate what I said earlier, a very enlightening session. A session where application of mind was stressed on. A session where sincerity and perseverance were the words which were discussed again and again. And it is not every day that we have the Executive Director of Insolvency and Bankruptcy Board of India coming and talking to students. So it is really our good fortune that we have had Mr. Kumar speaking to us. And with these words, I'm sure I have no doubt that the students have immensely benefited by the presence of Subodhji and Mr. Kumar. So may I now request Sushil to offer the formal.
So I would like to.
Yes. You want to say something?
Yes.
I forgot the name. Chartered accountant from
Raghavji.
Okay.
Raghavji. Yeah.
Mr. Maheshwari?
Raghavji, you want to add something?
Sir, I'd like to inform to all the students that regarding quiz, we have sent the email to all the students, the brochure, the link, and all the details with sample questions. So they have received the emails. So in case they are not able to locate anything, they can simply go to their email and get the brochure and all. And I have shared my email ID and our colleagues' email ID. And in case you have anything to ask regarding the quiz, any trouble, you can simply write to us. We'll be very happy to help. And immediately after you attempt the quiz, you will get the duly authenticated certificate of participation that you can share on some social media accounts to encourage others also.
Mr. Maheshwari, be in touch with Vandana Nagpal. She is the Director of Board of Studies, and she will be our points person as long as this quiz is concerned. You require any help from the institute, you be in touch with Vandana Nagpal. Right?
Thanks a lot, sir.
Okay.
She will also contact you, Mr. Raghav. No issues. He is having your contact details also. So both of you be in touch. Thank you, Saji Kumar sir, for nice deliberation. Always a smiling face. Ease out the tension of the participant. Lighter when you have taken the questions also. Thank you for sparing time. I hope it will motivate all our students. They will definitely look forward for future in this IBC and definitely take part in the quiz that will motivate them. Thank you, our past person, sir, Sri Subodh Agarwal, for giving the presentation. Detailed discussion he has taken for the topic, and definitely students will be benefited about their future as well as their exam also, because number of questions are coming in their exam also in IBCC. So they definitely get benefited of this. And Raghavji, thank you for explaining the quiz, and I think all are eager to participate in this quiz competition, which is can be seen from the questions I have received, but I have not posted those questions because all the answers given by you in advance, so I have not taken these questions. So thank you, Chairman sir, for organizing such type of program. It will definitely help all our students in their curriculum as well as extra curriculum, I can say, participating in the quiz. And thank you our office with Secretariat for providing all sort of support. Thank you each and everyone for joining here. Thank you. Thank you all the students.
Thank you very much, everybody. Thank you very much, everybody.
Thank you.
Thank you.